Bien, pues muy buenos días para todas y todos. Es un gran placer saludarles en esta magna presentación que nos va a brindar el distinguido profesor Martin Borowski, quien nos acompaña virtualmente desde Alemania. Sabemos que él es una de las personalidades más reconocidas en la actualidad en la dogmática de los derechos fundamentales y en general en el constitucionalismo alemán, europeo y estadounidense, por lo que es un gran lujo tenerlo entre nosotros en esta conferencia magistral con la cual arrancaremos una serie de eventos, un ciclo de conferencias permanente en el marco de las actividades del Instituto de Investigaciones Jurídicas de la Universidad Juárez del Estado de Durango, del Grupo de Investigación Transformaciones Sociales, Libertades, Derechos y Democracia Constitucional y de la Red Internacional de Investigación sobre Democracia, Derecho y Política desde México y Colombia. Algunos integrantes de dicha red están ya conectadas y conectados. Hemos arrancado puntualmente a las 10 de la mañana, tiempo de la Ciudad de México, en respeto al tiempo, al valioso tiempo y a la muy apretada agenda del profesor Borowski, quien nos habrá de dictar una conferencia sobre necesidad y ponderación que habrá de ser traducida también por un muy distinguido investigador mexicano, quien ya está radicado en Europa y es una de las mentes jóvenes también más brillantes en el panorama del constitucionalismo, que es Arnulfo Mateos, a quien le agradezco públicamente por haber hecho posible esta conferencia desde que lo platicamos en el verano en Génova, Italia, presencialmente. Ha sido un honor también contar con los buenos oficios de nuestro estimado Arnulfo, un orgullo mexicano que hoy triunfa académicamente en Europa. Antes de empezar, simplemente quiero agradecer también la presencia del director del Instituto de Investigaciones Jurídicas de la Universidad Juárez del Estado de Durango, el doctor Carlos Sergio Quiñones Tinoco, así como de integrantes, de miembros de nuestra red internacional de investigación y de nuestro grupo de investigación, la magistrada Alma Rosa Solís Ríos, el doctor Alejandro Vázquez Melero, Alejandro Londoño desde Colombia, el doctor Martín Gallardo García, la maestra María Eugenia Campos Zavala, y en fin, una serie también de distinguidas personalidades, no nada más de Durango, de México, sino de otros países. Entonces, antes de entrar en materia, quiero comentarles que la conferencia del profesor será en idioma inglés, pero como les habíamos anticipado, está disponible un canal de audio en español. En la parte inferior de su barra de herramientas en Zoom encontrarán un icono que dice interpretación. Si ustedes le dan clic a ese icono, ahí les va a dar la opción de escuchar la conferencia en su idioma original, el inglés, o bien con la amable traducción que desde un punto de vista técnico y como amplio conocedor de la obra del profesor Borowski nos brindará nuestro estimado Arnulfo Mateos. Entonces, les reitero, en la parte inferior derecha de su barra de herramientas de Zoom es donde se encuentra localizado este botón, este icono, para quien desee cambiar el idioma de la presentación de inglés a español. Y antes de ello, pues ya para dar paso al profesor Martín Borowski, que aunque no necesita presentación, voy a permitirme nada más leer algunos de sus datos curriculares más sobresalientes. El profesor Borowski es discípulo del gran jurista Robert Alexi, una de las voces más relevantes del constitucionalismo contemporáneo, y cuenta actualmente con la Cátedra de Derecho Público, Teoría de la Constitución y Filosofía del Derecho en la Universidad de Heidelberg, Alemania. Su obra académica aborda temas variados de derecho constitucional, teoría del derecho y derechos fundamentales en el ámbito nacional e internacional. Su tesis de doctorado se titula Los derechos fundamentales como principios, la cual cuenta hasta el día de hoy con una tercera edición, y su tesis de habilitación fue La libertad de conciencia y creencia en la ley fundamental. Los escritos del profesor Borowski han ganado prestigio no solamente en Alemania, sino en otros países de lengua germana como Austria y Suiza. Aunque su obra en español todavía es escasa, están siendo publicadas continuamente diversas traducciones de su obra. Una primera edición de su tesis de doctorado fue publicada por la prestigiosa Universidad del Externado de Colombia con el nombre de la estructura de los derechos fundamentales, traducida por Carlos Bernal Pulido. Actualmente acaba de ser publicada la segunda edición de su libro, Elementos esenciales de la dogmática de los derechos fundamentales, en donde Arnulfo Mateos, desde luego, ha jugado un papel central para que dicha obra pudiese ser publicada en México bajo bajo el muy distinguido auspicio de Tirán Leblanc. El profesor Borowski inició la carrera de Derecho en la Universidad Christian Albrecht en Kiel en 1985. Fue becario de investigación del profesor doctor Robert Alexi de 1992 a 1993 y su tesis de doctorado, Los derechos fundamentales como los principios, fue supervisada por el propio profesor Robert Alexi y recibió un premio por parte de la Facultad de Derecho. También recibió un nombramiento como docente particular por la Facultad de Derecho de la ya referida Universidad Christian Albrecht en Kiel en el año 2004 y ha tenido becas de investigación en universidades de Estados Unidos, de Reino Unido. Desde luego también ha tenido otras actividades académicas muy relevantes, miembro de la junta directiva de la sección alemana y vicepresidente de la sección británica de la Asociación Internacional de Derecho y Filosofía Social, miembro del Instituto Global de Estudios Legales de la Escuela de Derecho de la Universidad de Washington y autor de varias publicaciones y compilaciones sobre temas de derecho constitucional y dogmática de los derechos fundamentales. Vamos a ceder entonces la voz a nuestro invitado de honor, el profesor Martin Borowski, quien nos hablará sobre necesidad y ponderación. Dear professor, thank you for here with us, being with us. The audio is yours, and we are very pleased to have with us.
Thank you very much for the very kind introduction that you gave. And I shall thank my hosts here at the Universidad Juárez de Estado de Durango for kindly inviting me to give a presentation today. My topic is an aspect of proportionality, which is both theoretically important and practically significant. The paper has already been published in Spanish with the Suprema Corte de Justicia de la Nación in Mexico and is available on the internet. So the argument is compressed. If you want to go back and read something, this is possible. And the paper has not been published yet in either German or English. So it's available only in Spanish. Over the last couple of decades, constitutional lawyers all over the world have come to appreciate that the doctrine of proportionality is a crucial factor in assessing claims stemming from constitutional rights and international human rights. The first, more concrete manifestation of the doctrine of proportionality can be found in Prussia. Prussian police law is a special branch of administrative law at the end of the 18th century. Namely, in Title Section 17, Paragraph 10 of the Preußisches Allgemeines Landrecht of 1st June 1798, quite old actually. According to Karl Gottlieb Suarez, one of the two main authors of this impressive, comprehensive Prussian General Code of Law, embracing key aspects of constitutional law, private law, criminal law, and administrative law. The state was supposed to interfere with the individual's liberty only to the extent necessary for the sake of liberty of other individuals and or public safety. What is more, the benefit achieved by the state by means of the interference must outweigh the harm experienced by the individual. With this provision, a key idea of enlightenment was explicitly adopted in administrative law. It took, however, more than 80 years until this idea was given expression in the case law, namely in the second Kreuzberg judgment, Kreuzberg-Urteil, of the Prussian Administrative High Court from 1882. To be sure, proportionality remained, for the time being, an issue of administrative law rather than constitutional law. The German constitution at that time, Germany's Bismarck Constitution of 1871, did not record any constitutional rights. Then the Weimar Constitution of 1919, the first Republican constitution of the German Empire, contained a catalogue of constitutional rights: liberty rights, equality rights, and social rights, interestingly. The judiciary and academic commentary began to develop the first elements of the modern doctrine of constitutional rights, among them traces of the doctrine of proportionality, namely Rudolf Smens' balancing theory, Abwägungslehre, in the context of freedom of speech. Economically and politically troubled times made things, however, difficult. Only after 14 years under the Weimar Constitution, the National Socialists seized power in 1933. For the next 12 years, the collective, the people, was everything. The individual counted for little, Aryans, or nothing, non-Aryans. In answer to the atrocities of the Third Reich, the Hitler regime, the framers of Germany's constitution after World War II decided to take the rights of the individual seriously, more seriously than ever before in German constitutions. The Basic Law, Germany's constitution from 1949, middle of the 20th century, records liberty rights and equality rights and explicitly declares them to be binding for all three branches of government. It did not, however, explicitly provide for the doctrine of proportionality in a particular provision. It was left to the case law of the German Federal Constitutional Court to develop the structure of proportionality in greater detail in decisions from the 1950s on. As early as at the beginning of the 1960s, Peter Lerche, German colleague of the time, correctly stated that in Germany, proportionality counted as a widely accepted general principle of the Constitution. The proportionality test had become the key test in determining whether a parliamentary statute or any other act of the state proves constitutional from the substantive point of view. Two different strands of reasoning for justifying proportionality can be found in the court's case law. First, proportionality is conceived of as an integral component of the rule of law, Rechtsstaatsprinzip. Second strand, proportionality follows, the court claims, from the nature of constitutional rights, aus dem Wesen der Grundrechte. In modern parlance, one would say that proportionality counts as a necessary structural property of assessing claims stemming from constitutional rights. Both strands are plausible and mutually reinforcing. There is no need to prefer one strand of reasoning over the other. Obviously, there is debate, but this, I don't think we need that. In the following decades, the doctrine of proportionality migrated to many constitutional orders in Europe and beyond. To quote Sweetstone and Matthews, US Americans, on the proliferation of German-style proportionality, quote, by the end of the 1990s, virtually every effective system of constitutional justice in the world, with the partial exception of the United States, they say themselves, had embraced the main tenets of the doctrine of proportionality, close quote. What is more, the proliferation of proportionality reached public international law. It is widely accepted that assessing claims stemming from the European Convention of Human Rights by the European Court of Human Rights in Strasbourg involves, as a rule, proportionality analysis. I am obviously less familiar with the American Convention on Human Rights and the African Charter on Human and People's Rights, but it is my impression that proportionality plays a certain role in assessing claims stemming from rights in both instruments too, and that this also applies to universal instruments for the protection of human rights in the framework of the United Nations. Proportionality had also become a key criterion in the case law of the European Court of Justice in Luxembourg, the European Union Court. It's complicated in our continent. First, the institutional issue of the distribution of competences between the Union and its member states, some provisions here, and on the substantive issue of fundamental rights of the European Union, initially as unwritten general principles of community law, and now expressly provided for in the Charter of Fundamental Rights of the European Union, now a written catalogue. Following the Reformed Treaty of Lisbon, 2009, the European treaties now explicitly provide for the substantive aspect of proportionality in Article 51, Section 1, Clause 2 of this Charter, in conjunction with Article 6, Section 1 Treaty of the European Union. Beyond constitutional rights and inter- and supranational human rights, proportionality analysis also plays a central role in, for example, limiting market freedoms in the European Union and freedoms set down in the framework of the World Trade Association. In the international debate on proportionality, it is often emphasized that it can be regarded as the most successful recent export hit of German legal thinking. So Germany is not only exporting cars, Mercedes-Benz, BMW, Audi, and so on, but also legal thinking, export hit. Let me say that from the German point of view, this emphasis on the German origins is actually a double-edged sword. It might be understood as praise for the legal culture which developed proportionality with great clarity, which might sound flattering. The reference to the German origin of proportionality might also, however, be made with the overtone that it is a distinctly German structure, which cannot be easily, or even not at all, be transplanted to other legal cultures with their own and particular legal traditions and narratives. However, I think proportionality is a universal analytical structure. To be sure, no normative statement can be derived from an analytical structure alone. The analytical structure of proportionality needs to be complemented with normative premises. It is these normative premises where difficult traditions and conventions of different legal cultures come into play. And the analytical structure of proportionality cannot be specifically German, just as Isaac Newton's laws of gravity cannot be specifically British, or Hans Kelsen's notion of legal power, Ermächtigung, cannot specifically Austrian. To be sure, it is worth keeping in mind that the analytical structure of proportionality, A, is not the answer to every question, since subsumption plays an important role in applying the law too, and B, an analytical structure on its own cannot justify anything. It needs to be complemented with normative premises that need to be justified then by means of legal interpretation. Good. Proportionality, in its broader sense, comprises three criteria, namely suitability, necessity, and proportionality in its narrower sense. I think this is by and large well known, but we need to be precise here. This is the most frequent systematization in the case law and in the literature. There are also systematizations with 2 or 4 prongs. There are some differences. I will generally focus on proportionality analysis in the context of constitutional review of legislative measures undertaken by a constitutional court, or Supreme Court, if you want. The characteristics in other contexts are, I shall say, mutatis mutandis, similar. Suitability. Suitability requires that the legislator pursue a legitimate end and that the means must be appropriate to achieve or, at the very least, to promote that end. That is actually a dual requirement. First, the end pursued by the legislator must be legitimate. Illegitimate ends are excluded from the outset. They have no basis that would justify interferences with constitutional rights. Note that the question which end counts as legitimate is a normative issue that needs to be determined within the constitutional order in question. For example, the German constitution prohibits any discrimination on grounds of race. This is to say that racial purity of the population does not count as a legitimate aim. The question is not how much weight this end exhibits compared to competing rights and goods. It exhibits no weight at all, zero, nothing. This is the point. Second, the means employed by the legislator must at least promote the relevant end. This now is an empirical question of instrumental rationality. If we employ the means, will the end be promoted? Note that the degree of the promotion of the relevant end plays no role in this context. The effect only has to be positive, even if it proves tiny. This empirical question, whether a certain means promotes a certain end, can be rather complex. For example, whether a certain parliamentary statute promotes employment may well depend on intricate side constraints, on a concerted or contradictory behavior of various economic actors who all pursue their own ends. This can be very difficult. Often, at least, a certain degree of empirical uncertainty remains, even if all expert opinions are considered. In constitutional review, courts cannot simply replace the legislator assessment of the relevant empirical issues with their own empirical assessment. Courts have to grant empirical discretion to the legislator. The greater the empirical uncertainty, the more discretion for the legislator. I will return to the issue of discretion later. So the dual criterion of suitability is sometimes split into two different prongs of proportionality, namely, first, legitimate aim, normative element suitability, second, suitability, then only the empirical question of instrumental rationality, then free necessity for proportionality in its narrow sense. One can do that. This four-pronged version of proportionality is, however, only a different systematization of the very same set of criteria. It's just different numbers, so to speak. It does not imply a difference with an eye to the criteria. It is really rare that a legislative measure fails the suitability test. The leading case in German constitutional law is the falconry license case. The German federal legislature treated falconry, hunting with a bird, the falconry, as a case of hunting, technically. According to the relevant statute, everyone who wanted to engage in falconry was required to have a general hunting permission and, additionally, a special falconry permission. Hunting normally involves killing wild animals with firearms. Thus, it seems reasonable that the general hunting permission is made dependent on an exam on handling firearms. Firearms are dangerous, so you need an exam. since the possession and the use of firearms, even for hunting purposes, is strictly regulated in Germany, very strict. This exam is very onerous and requires lengthy and burdensome training. The point is, however, that firearms play no role at all in falconry. The weapon in falconry is basically the bird of prey, which catches small animals that are then killed by the falconer using the traditional falconer's knife, Falknermesser. The falcon then gets a reward from the falconer, and so he carries on doing that. The falconer cannot use a firearm to kill the prey, since that would scare the falcon, the bird, away. The falcon would never return to the falconer, would just fly away, would be gone, never come back. This is to say that firearms are useless and even counterproductive in falconry. Training and knowledge with an eye to firearms is, in the words of the German Federal Constitutional Court, in my translation, not at all related to appropriate falconry and potential dangers arising from falconry. There is no danger from the use of firearms because no firearms are used in falconry. The requirement of passing an exam on firearms is not suitable. Necessity. Applying the criterion of necessity, the means employed must have the least restrictive effect. This is to say that there is no alternative means that infringes to a lesser degree on the individual's rights, but promotes the end at least as well, equally or even better, compared to the means employed by the state. This is the economic question of Pareto optimality applied to the law. The seminal German case here is the decision on chocolate Easter bunnies. In Germany, chocolate figures are traditionally popular. Santa Claus for Christmas and Easter bunny for Easter. And in between you eat just chocolate. At some point, cheap figures made from fake chocolate, basically cheap fat, sugar, and brown color with hardly any cocoa beans, together with puffed rice, some kind of popcorn made from rice, entered the market. This posed the danger that the consumer would be misled to believe that these fake chocolate figures were proper chocolate figures. To avoid such mistake, the sale of fake chocolate figures was completely banned by means of a federal regulation. Such a ban pursues the legitimate end of consumer protection and promotes this end. If fake chocolate figures may not be sold, no one can mistake them for something that they are not, namely proper chocolate figures. The German Federal Constitutional Court ruled, however, that such a complete ban of the sale of such fake chocolate figures is not necessary. There is an alternative means in the sense of necessity, namely a labeling requirement. An appropriate labeling requirement makes sure that the consumer is made aware that the figure in question does not contain proper chocolate, but fake chocolate. If people are happy to buy fake chocolate and know what they are getting, no one is being misled. A labeling requirement certainly infringes to a lesser degree on freedom to pursue one's business as one wishes, Berufsfreiheit, according to Article 12, paragraph 1 of the German Constitution, compared to a complete ban of the sale of fake chocolate figures. One is permitted to sell figures made from fake chocolate if only they are labeled appropriately to avoid mistakes on the part of the consumers. This is the first part of the alternative means. The second element of an alternative means is that this means must promote the relevant end equally or better. The German Federal Constitutional Court ruled in 1980 that a labeling requirement promotes, as a rule, consumer protection equally compared to a complete ban of sale. This strand of argument can also be found, roughly at the same time, in the Cassis de Dijon decision of the European Court of Justice in Luxembourg, in the context of non-tariff barriers to trade, free movement of goods in the common market. Germany regarded a complete ban of a French liquor, Cassis de Dijon, some kind of sweet alcohol stuff, as necessary, since it contained traditionally too little alcohol to be considered a liquor in Germany. Germany has stronger alcohol than France, it would seem. The European Court ruled, however, that a labeling requirement would suffice. A complete ban was not necessary in the sense of necessity. In assessing the necessity of a legislative means, two aspects play a role: the degree of the promotion of the end and the interference with the competing constitutional right. Let us assume now that we measure the degree of promotion of consumer protection in apples. It's our currency now, apples, and the severity of the interference in oranges. It's another currency, oranges. Let's assume further that a non-complete ban of the sale of fake chocolate interferes with freedom to pursue one's business as one wishes, the right, at the cost of 4 apples, and promotes consumer protection to the value of 3 apples, 4 oranges, 3 apples. The alternative means of a labeling requirement interferes with freedom to pursue one's business as one wishes at the cost of 2 oranges and promotes consumer protection also to the value of 3 apples. These assumptions make clear, artificial of course, but let's make them, make clear that the labeling requirement interferes less severely and promotes consumer protection to the same degree. 3 apples for both means. In short, we have to look whether there is a means that is better in terms of liberty, fewer oranges, and at least equally good in terms of the promotion of legitimate ends of the legislator, same number of apples or even more apples. 3 remarks now are worth mentioning, and this example will be extended in what's coming. 3 remarks are now worth mentioning. First, for applying the criterion of necessity, as explained above, we need no exchange rate between oranges and apples. We don't need an exchange rate. We only need to look for means that are better in terms of oranges and at least equally good or better in terms of apples. This is all we need to establish. Second, means that are equally good in terms of liberty, oranges, and equally good in terms of the promotion of the legislative end, apples. So if apples and oranges are the same in both cases, this is not an alternative means in the sense of necessity. No one can claim in constitutional review that such a means is better than the original means chosen by the legislator. Both measures are equal from the point of view of Pareto optimality. The legislator can choose either. The Constitutional Court can never criticize the legislator for preferring one over the other. They are equally good. Third, even if an alternative means is equally good in terms of liberty, but better in terms of the promotion of the end, more apples, this is not an alternative means in the sense of necessity from the point of the view of the constitutional right. Of course, here is an optimization issue. We can have more promotion of the legitimate end at the same cost in terms of liberty, which is better from the standpoint of the Constitution seen as a whole. This is, however, Pareto optimality judged from the point of view of the legitimate end, the principle that competes with the constitutional right. The relation between the constitutional right and the limiting reason for this right is symmetric, and you can assess necessity from both standpoints. The evaluation needs to be inverted if you change the standpoint. Actually, this symmetry is suggested by the fact that constitutional rights are often limited by constitutional rights of others. That a legitimate means is not necessary from the standpoint of the legitimate end, the limiting reason for the right, does not, however, imply a violation of the constitutional right. If more consumer protection can be achieved with the same intensity of interference with freedom to pursue one's business as one wishes, this is completely indifferent to these freedoms, which of these two means is chosen. This might mean, for example, that a constitutional complaint in such a case filed by the holder of the freedom to pursue one's business as one wishes, the right, would not be successful. It depends on the doctrine of constitutional law and procedural law, which consequences the finding that a certain legislative means is not necessary from the point of view of the constitutional end would have. The distinction between absolute and relative constitutional ends might play a role here, and also the question in which review procedure a constitutional court comes to that finding. But this optimization issue is nothing I'm concerned with more here. I shall move on to the third prong of proportionality, proportionality in its narrow sense. There are some terminologies that may, on first glance, suggest that proportionality analysis only has two prongs, namely suitability and necessity. It was a key phrase in the European Convention of Human Rights indicating that the proportionality test is necessary in a democratic society, according to some provisions. However, the more recent case law of the European Court of Human Rights at Strasbourg has made clear that this embraces all three prongs of proportionality: suitability, necessity, proportionality in its narrow sense. And this applies also to the European Union Court of Luxembourg. Proportionality in its narrow sense requires that the interference with the individual's right and the promotion of the public authority's legitimate end be balanced. If the interference outweighs the promotion of public authority's legitimate end, the interference counts as disproportionate and therefore unconstitutional. If the promotion of public authority's legitimate end outweighs the interference, or if both exhibit equal weight, a stalemate case, the interference does not count as disproportionate. To illustrate this by means of the example of the labeling requirement for fake chocolate Easter bunnies, the decision needs to be taken as to whether 2 oranges, degree of interference with freedom to pursue one's business as one wishes, are outweighed by 3 apples, the degree of promotion of consumer protection. It is often said that apples and oranges are incommensurable, which is true. Balancing is the process of making incommensurable entities commensurable from the point of view of a certain constitutional framework. In this process, arguments on the weight of the principles that are balanced are key. The idea of balancing has attracted much attention, particularly during the last 2 decades. To briefly mention here only the 2 most important strands of criticism, critics have argued that balancing fundamental rights provides for either too little or too much commitment. The first strand of criticism claims that balancing fundamental rights deprives them of the force that they ought to exhibit in law. For balancing, the critics would have us believe, does not count as a rational method. In reply to this criticism, Robert Alexy formulated some fundamental laws of balancing in the 1980s and developed the internal justification of balancing judgments further in the early 2000s by proposing the weight formula. The second strand of criticism, advanced by Ernst Wolfgang Böckenförde in the 1990s, holds that constitutional review of parliamentary statutes by means of proportionality analysis deprives the democratic process of the central role it deserves. If the judges of the Constitutional Court are empowered to annul parliamentary statutes on the basis of proportionality considerations, they seize, he would have us believe, the role of judge kings. The issue seems to be aggravated by Ronald Dworkin's one right answer thesis, according to which there is supposedly one and only one right answer for every balancing. It is true that Ronald Dworkin made, on one hand, important contributions to the modern theory of legal principles, and supported, on the other, the one right answer thesis. Principles theory has moved on, however, in developing different forms of discretion and balancing. This is the reply of principles theory to the second strand of criticism. Constitutional court judges are not transformed into judge kings because they have to grant sufficient discretion to the democratically legitimated parliament. The debate on whether the weight formula has become rather complex and technical, and I shall refrain from going into the details of this formula for their own sake. After all, this presentation is primarily devoted to the second criterion of proportionality analysis, necessity. And I mentioned shortly ago that applying the criterion of necessity does not require balancing, establishing commensurability between apples and oranges by means of legal argumentation. If this was the whole and final truth, my presentation would stop here with the clear message that proportionality in its narrower sense requires balancing, while applying necessity does not. This is not, however, the whole and final truth. There are actually two issues that suggest that balancing might well play a role in applying the criterion of necessity. I shall only roughly sketch the first and explain the second in a more thorough and detailed fashion. I have already mentioned, first short thing, I have already mentioned, albeit in passing, that in constitutional review, the Constitutional Court has to grant a certain extent of discretion to the Parliament. This actually applies in the context of all three criteria of proportionality. There has been quite a debate on the issue of discretion in proportionality in its narrower sense, as reconstructed by the weight formula. On the one hand, different forms of structural discretion, namely discretion and balancing established by stalemates, and setting discretion, and means selecting discretion. On the other, epistemic discretion, which is brought about by formal principles. Formal principles are a particularly contentious issue, on which I disagree with Robert Alexy, who radically changed this theory 10 years ago. I am defending a certain reconstruction of his earlier theory, which is also somewhat parallel to Ronald Dworkin's notion of conservative principles, against Alexy's more recent theory, which he calls the epistemic model. Add Jan Reinhard Siegmann's model of balancing competing judgments on balancing substantive principles, complicated name, into the mix, and different versions of these three fundamentally different models, and you get a sense of the complexity of the debate among the supporters of principles theory. And there are, of course, the critics of principles theory who object to this or that model of formal principles in this or that particular reading. A more detailed inquiry would immediately develop into a topic in and of its own. It is, however, not immediately clear as to whether and how an appropriate solution of considering epistemic discretion, epistemic uncertainty and balancing can be transformed to the assessment of necessity, since the assessment of necessity does not involve balancing in the sense of establishing an exchange rate between what I call apples and oranges. It may be that the extent of epistemic discretion to be awarded in assessing necessity proves to be determined by means of a balancing in the background or at some meta level, which would imply a distinction of levels. An application level on which the criteria of necessity with a certain extent of discretion are applied, and a justification or meta level on which the extent of epistemic discretion at the application level is determined and justified. If this is true, balancing may well play an indirect role. This is the point, an indirect role in applying proportionality. But this requires more thinking, I think, more thinking and writing. Now, there is another issue, and I will focus on that. Another issue that might suggest that applying the necessity involves balancing. And this is the issue, now a frightening name, the issue of Kaldor-Hicks optimization. Sounds complicated, is actually not complicated. Now, what do I mean by that? This may again be illustrated by means of a decision of the German Federal Constitutional Court, the employment lease decision from 1987. Germany had and continues to have a rather strict employment law with much social protection for employees. This is completely different from your northern neighbors and the European branch of the Anglo-Saxons in Great Britain, which are both more in favor of the policy of hire and fire. Strict employment law is great from the point of view of the principle of the social state. It is, however, economically less flexible for companies. This is why companies find it attractive in case of a short-term or mid-term need of a greater workforce, not to hire additional employees themselves in Germany, but to lease employees from companies which specialize on the business of employment lease. The inflexibility of German employment law remains then a problem for these employment lease companies. This is why they charge a premium for leasing out their employees so that their business remains economically viable. At the beginning of the 1980s, it had become apparent that there was a serious problem with black labor in Germany, particularly in the construction sector. Foreigners without residence and work permits were often employed. Social security contributions and taxes were frequently not paid by the employers and employees alike. It had proved very difficult for the responsible German state administration to enforce the law in this area, since the place of work changes so often in the construction sector. What is more, it is really difficult to effectively close off a construction site. Against the backdrop of these difficulties, the German federal legislature decided to completely ban employment lease in the construction sectors. It's just forbidden, full stop. Among others, a company that had specialized in employment lease in the construction sector filed a constitutional complaint and claimed that the freedom to pursue one's business as one wishes, Berufsfreiheit, according to Article 12(1) German Basic Law, was violated. They claimed that neither them nor their employees had ever engaged in any black labor practices, so that it would be unfair that they had to suffer as a result from their competitors' wrongdoings. Since it was plausible that the law enforcement measures traditionally employed were, in terms of quantity and quality, of questionable effectiveness, it was quite obvious that the old situation was not an alternative means in the sense of necessity, compared to a complete ban of employment lease in the construction sector. The traditional measures were obviously less effective. The complainants now put forward an interesting argument. They said that a complete ban of employment lease is not necessary in the sense of necessity, since the state could intensify law enforcement measures to the point of effectiveness. The Federal Constitutional Court was not impressed. In the greater section of the judgment on proportionality, the court generally outlines and applies the three criteria of proportionality, as mentioned earlier in my presentation. Particularly interesting, however, is the passage on necessity. An easy way out would have been for the court to claim that intensifying law enforcement measures for combating illegal forms in terms of employment can never be equally effective compared to a complete ban of employment lease. This is not, however, what the court says. Rather, it says that, according to the plausible considerations of the legislator, they could consider the significant financial means required for intensifying law enforcement measures as unacceptable, unzumutbar. This is to say that a complete ban of employment lease in the construction sector remains constitutional, since sufficiently intensified law enforcement measures would be too expensive for the state. Nota bene, all this in the section on necessity, the second prong of the traditional proportionality test. The expression unacceptable, unzumutbar, that is used in the court's reasoning is a typical expression for the balancing stage, proportionality in its narrower sense. To add to the confusion, the court throws in a remark that the individual cannot expect unlimited financial means from the state, citing a seminal case on the social right to university education, the numerus clausus decision. And I understand that our translator will now explain what the numerus clausus decision is on the Spanish channel, and I would be grateful if he can give me a sign if he is done. You are done. Okay, good, I can carry on. Thanks. Good. The employment lease case found some attention in more theoretic academic commentary, but relatively little, interestingly. Considering how often comparable issues arise in legal practice, it is slightly astonishing that one finds hardly any mentioning in the standard literature on proportionality in constitutional law, and if so, very much in passing. The reconstruction that is probably most faithful to the court's reasoning offered in the German debate on this problem is that it actually is an issue of necessity, refined now by the Calder-Higgs criterion. This criterion is an economic criterion, according to which a distribution of wealth is to be preferred if those who are advantaged by a measure can compensate those others who are disadvantaged by this very measure. Applied to our example of the ban of employment lease, this is to say, if the benefit in terms of liberty of the companies involved has more weight from the point of view of the Constitution than the financial burden for the state, the balance is positive. That no actual compensation in terms of money or so takes place is not a problem. That hypothetically a compensation would be possible is indicated by the higher weight, metaphorically speaking. This is to say that this means counts as an alternative means in the sense of a refined criterion of necessity, Pareto optimality combined with the Calder-Higgs criterion. If, however, the financial burden for the state outweighs the benefit in terms of liberty, it is not an alternative means in this refined version. A refinement, if one does that, of necessity along these lines has far-reaching consequences. To begin with, the range of potential alternative means would be significantly broadened. What is more, we could no longer say that applying the criterion of necessity does not depend on balancing Now, in addition to oranges and apples, lemons come into play. Let us assume that the complete ban of employment lease in the construction sector promotes the value of prohibiting illegal employment in the construction sector to the value of 4 apples, and that it harms freedom to pursue one's business as one wishes with a weight of 4 oranges. Even if the refined version of necessity does not require us to establish commensurability between apples and oranges, but beyond apples and oranges, a third factor comes into play, that is, lemons, the financial burden for the state. The appearance of this third factor in the refined version of necessity, Kaldor-Hicks, requires that commensurability between oranges and lemons be established. Let us assume that there is, compared to the total ban of employment lease in the construction sector, an at least equally effective means for apples, namely much intensified law enforcement measures, which is, however, quite expensive for the state. There is still an interference with freedom to pursue one's business as one wishes, the right, since everyone is subjected to strict controls. Let's say 1 orange. In addition, the financial means required for the tight controls harm the state finances to the weight of 4 lemons. Now the question arises as to whether the original means, the complete ban with the cost of 4 oranges and no lemons, is to be preferred over the alternative means, the expensive intensified controls, which harms to the cost of 1 orange and 4 lemons. The decisive question is now, is paying the price of 1 orange and 4 lemons higher than paying the price of 4 oranges? If yes, the alternative means is not better in terms of the Kaldor-Hicks criterion. It is not an alternative means, even in the refined sense of necessity. And I think this is the employment lease decisions case. On the contrary, if paying the price of 4 oranges, original means, is higher than the price of 1 orange and 4 lemons, alternative means, a hypothetical compensation in the sense of Kaldor-Hicks criterion would be possible. The original means would not be necessary in the refined version. If no relevant difference of the weight of 4 oranges and 1 on one side and 1 orange, 4 lemons on the other side can be established, we have a stalemate. None of the two means then stalemate is to be preferred over the other from the point of view of the Constitution. In this case, the legislator would be free to choose the means that seems best to them. If one broadens this view, we are talking about now financial means for the state. If one broadens the view, this structure of the refined version of necessity is actually not limited to a financial burden for the state in a potentially alternative means. Every constitutional end which is additionally harmed by a potential alternative means can result in the same structure. For example, environmental protection, or even other liberties or freedoms of other fellow citizens. The only condition is that the ends are not immediately commensurable, so that incommensurability needs to be established by balancing along the lines mentioned between oranges and lemons, now in this case. I should also mention that the talk of apples, oranges, and lemons and the use of arithmetic numbers is highly metaphoric and only employed for the purpose of illustration. More sophisticated, albeit less instructive, scales could be used, geometric sequences in limited scaling, such as Alexi's triadic scaling or double triadic scaling, is known from the weight formula. What is more, all forms of discretion that have been developed in the discussion of balancing can also play a role in this Kaldor-Hicks balancing between oranges and lemons. Now, this leaves us with 2 questions, and I'm coming to the end. This leaves us with two questions, the if question and the where question. The if question asks whether Calder-Higgs optimization is actually relevant in constitutional law. In my view, the answer is a clear but qualified yes. Imagine a situation in which there is a potential alternative means which gives rise to a very modest additional cost in terms of financial burden for the state, but limits the interference with the individual's liberty dramatically. So that Calder-Higgs optimization in this case gives rise to an undisputable and significant overall gain. This is, in my view, a strong argument to prefer this alternative means from the point of view of the Constitution. Considering that there will be, as a rule, epistemic uncertainty and a corresponding extent of epistemic discretion for the legislator, and that a combination of different forms of discretion tends to result in exponentially greater overall discretion, a constitutional court will only rarely come to the conclusion that a Calder-Higgs optimized alternative means renders the means chosen by the legislator unconstitutional. Many cases of balancing are hard cases. There are, however, also plain cases of balancing. The fact that positive plain cases of Calder-Higgs optimization are imaginable suggests that the if question be answered positive, with the qualification that such cases will be rare. The where question is actually less important, but more difficult to answer. To begin with, one thing is clear. Once the if question has been answered in the positive, nowhere is not an option, since Calder-Higgs optimization needs to be undertaken, it needs to be embedded in the traditional structure of these prongs of proportionality. It needs a place. Second, Calder-Higgs optimization presupposes Pareto optimality, so that any location in the suitability prong and in the necessity prong before Pareto optimality can be ruled out. This cannot be one of these stages or before it. This might be taken to suggest amending either the second or the third prong of proportionality. And this is the state of the debate in German constitutional theory. Refining necessity in the sense of Pareto optimality by means of Calder-Higgs optimization is, as far as I can see, the prevailing opinion among those who have discussed the issue in German constitutional theory and constitutional law. The problem is, however, that adding balancing, even if only, in my metaphor, between oranges and lemons and not between oranges and apples, changes the application of necessity methodologically to such an extent that one can no longer claim that this is necessity in some version. It would be something new and rather different. Adding Calder-Higgs optimization to the third prong, proportionality in its narrow sense, would not change this criterion methodologically, since balancing is undertaken here anyway. Although traditionally, to use my metaphor, between apples and oranges, with the original means of the legislator, and not between oranges and lemons, foreign alternative means. The problem here is that Calder-Higgs optimization requires that alternative means are considered, which is traditionally not done in proportionality in its narrow sense. Only the means chosen by the legislator here is traditionally evaluated. To conclude, Calder-Higgs optimization has structurally something in common with both necessity and proportionality's narrow sense, respectively. But the respective differences prohibit to treat it as an element of either the former or the latter. If it needs to be there, it cannot come before necessity, it cannot be part of either necessity or proportionality in its narrow sense, these three premises permit only one solution: to accept Calder-Higgs optimization as a fourth freestanding criterion of proportionality, located between necessity, characterized by the classic form, characterized by Pareto optimality, and then afterwards proportionality in its narrower sense. So then the new structure with genuinely four different criteria would be suitability, necessity in its classic form, 2, free Calder-Higgs optimization, alternative means with this balancing between lemons and oranges, and 4, then after this has been done, proportionality in its narrower sense. Of course, in cases in which there is no obvious issue with Calder-Higgs optimization, not much or even nothing needs to be said on this prong, and this applies to most cases. This has, however, never been different for necessity in cases in which no alternative means in terms of Pareto optimality suggest themselves, and so this is actually something we know from the traditional structure already. Ladies and gentlemen, thank you very much for your kind attention. And if the event leaves some space for discussion, of course, I'm happy to take your questions and look forward to comments and questions. Thank you very much.
Dear Professor, thank you very much for your brilliant presentation. It has been an extraordinary lesson that enlightened us about many of the current challenges of constitutionalism and fundamental rights. If you agree, we can have some time for questions and answers. A nuestro amable auditorio, si alguien desea hacer el uso de la voz, en este momento el profesor tiene todavía algunos minutos de su valiosa agenda, entonces pueden hacerlo por la vía de chat, pueden también de viva voz, aquí entre Arnulfo y yo podemos hacerle el planteamiento al profesor, entonces pueden hacer su pregunta en español o en inglés sin ningún problema, entonces el micrófono está abierto para quien desee realizar alguna pregunta. Ojalá que hubiese algún planteamiento en lo que se da ahí alguna pregunta. A mí me gustaría hacer nada más un planteamiento rápido y con el auxilio, desde luego, de Arnulfo para la traducción de la respuesta del profesor Borowski. Dear Professor, I would like to make the following approach. Proportionality has gained a lot of ground in the work of various Latin American courts, such as the Mexican or Colombian courts, for example. There are several leading cases in fundamental rights that have used it as a method. My question would be, how does proportionality respond to those doctrines that indicate that it increases judicial discretion, the government of judges, and that it weakens fundamental rights, democratic bodies such as Congress and the people themselves? Para nuestro auditorio, le hice nada más al planteamiento al profesor en el sentido de que la proporcionalidad ha ganado terreno en América Latina, en el trabajo de la Corte Mexicana, de la colombiana, pero que hay algunas doctrinas que la cuestionan en el sentido de que incrementa la discreción judicial, apunta a un posible gobierno de los jueces de forma autoritaria o arbitraria, mejor dicha, más que autoritaria, y que debilita a los derechos fundamentales, a cuerpos democráticos como el Congreso y al pueblo en sí mismo. Professor, if you can give us an answer, please.
Yeah, thank you very much. To begin with, proportionality allows to so to speak, to tailor the definitive protection of rights uh, in the best, so to speak, fashion possible. And we should not forget that if we have on the limiting side of constitutional rights, proportionality, we can actually accept a relatively wide scope of the constitutional right in the first place. So you can be generous with an eye to what is prima facie covered by a constitutional right, because if there is, so to speak, too much covered on the side of the scope of the right, on the side of the legal consequence when it comes to the limitation of that right, you can be fairly flexible. So those methodologies who claim that they are very strict in terms of limiting constitutional rights often have to pay the price that they have to make the scope of the constitutional right in the first place really narrow. So we should not only look at the side of limiting the right, but we should look actually at the whole model. And then I think I think you see that the assessment that it weakens doesn't really have a strong case to begin with. First point. Now, the second point, I emphasized that proportionality actually is a structure. And what it basically rules out, proportionality is a structure, if you look at the balancing requirement, doesn't really rule out much normatively. It only rules out one thing. It rules out that you say, in this case, the right, the interference with the right outweighs the limiting reasons, but it is not violated anyway. Okay, you can't say that, yeah? But the point is, proportionality is often comes, it is developed in time and space, in a context. It is developed in a constitutional order in which a certain weight is attributed to constitutional rights and a certain weight is attributed to the limiting reasons. Now, proportionality is only the structure. Now, the normative premises need to be justified. And if a court applies proportionality and says, okay, we have to use the structure, but in terms of the normative outcome, so how severe is the interference? How much weight do the limiting reasons have? If courts say, well, we can do what we want, this is, so to speak, then not a proper justification of these normative premises that are used in applying proportionality. So my point is, a balancing judgment undertaken by any court whatsoever, national or international, a balancing judgment is as good as the justification of these normative premises. Are there convincing arguments put forward that the interference is just a light interference? Is this coherent with an eye to the case law beforehand, for example, or to comparative case laws and other constitutional and neighboring constitutional orders on the same continent, for example? You can ask all this question of coherence. Now, it comes down to the justification of the normative premises in proportionality. And if you have, so to speak, adequate requirements that the justification needs to be good and convincing, then I think proportionality and the application of proportionality leaves much less discretion to courts than is commonly believed. Obviously, if there is a constitutional court, the constitutional court's decision in this case is final, so there will not be an appeal. Well, it may be an appeal with the international court. So a national constitutional court in Latin America will face the San Jose court, for example. So there's some kind, it's not the same standard, but it's a comparable standard. But so might be some, but with the San Jose court, it can be wrong, and the yardstick can be wrong. But if you look at decisions, so to speak, not stare at the very single decision we are now facing, but if you look at this decision from a more systemic fashion, I always tell my students, actually, after the decision is before the next decision. And there will be critical evaluation of commentary, of other legal orders and so on. And so there will be critical debate, and this is where critical evaluation comes into play, and some kind of some influence on the next decisions may take place. The issue of discretion is quite technical. My answer is already long, so I shall stop here with my answer. But discretion needs some attention, and I think there has been there's now agreement that, so to speak, before we had proportionality, there was too little commitment of the legislator, so they could do what they want. There was no standard. Now we've developed proportionality, which actually tends to be too strong, and then we need to develop forms of discretion and criteria how much discretion is granted. This is an area we're working on, and I think that this is my last remark on that point. That this is despite all similarities between the European Convention and the American Convention. The European Convention actually has now been, with the 15th additional protocol, now the subsidiarity principle and the margin of appreciation for the member states has now been explicitly pronounced. And this is something that is a development that has, well, I shall say, not taken place in your continent, or I could say it more pejoratively, is still awaiting to happen, which may not be true. There may be reasons not to. You are the experts on your continent, but structurally, I think if you look at the German national order and the Strasbourg, the convention, the issues are very much converging, and I would be surprised if this is not a universal issue. Yeah, sorry for the long answer, but it was such a good question. Thank you. Yeah.
No, thank you, professor. Arnulfo, pues nos puede ayudar un poquito con la traducción. El micrófono es tuyo, estimado Arnulfo.
Oh my goodness, he has to translate. Oh yeah. Oh.
Muchas gracias, Arnulfo, por tu excelente traducción de la respuesta del profesor Borowski. No sé si hubiese alguna pregunta más. Todavía tenemos ahí un par de minutitos en caso de que la hubiere en la sección de chat o si alguien desea hacer el uso de la palabra. César Benavides de la Universidad de Antioquia en Colombia. Ha levantado la mano. Por favor, César, en inglés o en español, como tú gustes. Bienvenido.
Muy buenas tardes para todos. Saludos desde Medellín, Colombia. Muchas gracias, doctor Alan, doctor Borowski. Y la pregunta puntual es si el doctor Borowski, por favor, nos podría ampliar un poco más las diferencias entre la discrecionalidad estructural y la discrecionalidad epistémica de cara a la explicación sobre el test de proporcionalidad. Muchas gracias.
Gracias a ti, César, por tu muy buena pregunta. Professor César Benavides from Colombia makes this question. Could we expand the differences between structural and epistemic discretionality, please?
Yeah, thank you. This is a very fundamental question. It kind of is only loosely related to my presentation, but I mentioned it myself, and of course, I'm perfectly happy to answer it. Okay, how to begin? At the outset, I mentioned the Allgemeines Preußisches Landrecht from 1798, the very beginning of the development of proportionality. Actually, at this very beginning, in this Prussian version, more than 200 years old, there was actually some difference. Many people don't notice that. It was required in this old version that in the case of a stalemate, when the severity of the interference and the weight of the limiting reasons were the same, the right was considered violated in Prussia. Now, we don't do that anymore. This has long gone, and we think that if the right, the weight of the right and the weight of the limiting reason is actually the same, that then there is no violation of the fundamental right. And this is why actually we phrase it negatively. We do not say the interference must be proportionate. We say it must not be disproportionate. So this double negation plays actually an important role here. And it tells us that the stalemate means that if a constitutional court reviews what the legislator has done, and they think it's a stalemate, both issues have the same weight in balancing, there is no violation. Now, interestingly, this is the first instance of structural discretion. This is why I mention it. The first instance of structural discretion. Now, the point is, generally, the proportionality issue has always been looked at from the review perspective. We have a constitutional court reviewing something. And now the point with structural discretion is, this discretion is actually discretion for the legislator, to the effect that the constitutional court cannot say that there's a violation if the issues have the same weight. It's the legislator's discretion, the legislator's structural discretion. Now, this is, so to speak, normal to us. This seems understood, but technically, so to speak, philosophically, you could say, well, this is discretion for the court. If the legislator has taken a measure and they have the same weight, the right and the limiting reason, then discretion would actually be the constitutional court's discretion to find it unconstitutional or not. But we don't do that because it's a review balancing that we undertake. And this stalemate case, now, The question, of course, is, can there be stalemate cases, or do we have some kind of infinitely fine distinctions we can make in the values? And this is one of these the assumptions of Robert Alexis' White formula, that we cannot. Now the point is here, there is no uncertainty involved. We can theoretically with all certainty determine that these two issues have the same weight and there is discretion. Now the second form of structural discretion is end-setting discretion. Constitutions can have absolute ends, in the sense this is an end that the state has to pursue. The state must pursue that end. For example, in the German Constitution, this is environmental protection. So the state cannot actually try to promote environmental protection. The state has to. The question is not whether it has to promote environmental protection. The question is to what extent and at what cost. Because environmental protection needs to be balanced with all other competing constitutional values. But it's, so to speak, an absolute end in the sense the state has to pursue it. Now, the limiting clauses in constitutional rights, at least in the German version, with the European Convention on Human Rights, it's different because they mention specific limiting reasons. The German Constitution, in the German Constitution, the limiting clauses are open-ended. They basically say it has to be a legitimate end. So the legislator actually is empowered to decide for himself that a certain end is worth pursuing, and by doing so, the legislator is setting an end. And now the point is, this is not an end that, so to speak, absolutely has to be pursued by order of the Constitution, so to speak, but it's the legislator's decision to pursue this end or not. And so to speak, setting that end is some discretion that the legislator can undertake, and there's no uncertainty involved. No uncertainty. It's, so to speak, a structural thing. And the third example is more complicated. I should just briefly mention that in the case of positive rights, the state has to pursue, so to speak, the end of achieving the positive right, but there may be different means to do that, completely different means to achieve that. And if they are equally good in terms of benefit and cost, then the legislator is, so to speak, structurally free which of those equally good means to choose. There's no uncertainty involved. If it comes to epistemic discretion, uncertainty comes into play. We don't know. And we try to remove the uncertainty by getting expert opinions, by employing some kind of scientists who tell us as much as they can. But if you can't remove uncertainty, then the question is, how do we deal with this imbalancing? And the basic idea, there are different ways of doing that, but one possible and in some contexts meaningful way is to say, if I have a relatively important end, but I'm not really certain that actually employing the means will further that end. There's some uncertainty empirically involved. In balancing, you can use that as an argument to say, okay, this is an important end, but because we don't really know for sure that it will be furthered, the value, the weight of this end, because of that uncertainty, is actually in the balancing somewhat lower. So my point is, the very moment if you are willing and tempted to grant some discretion to the organ or institution that actually took the decision that is to be reviewed. Now, if uncertainty comes into play, you're talking about epistemic discretion. With these three versions that I mentioned beforehand, this is structural discretion, there is no uncertainty at hand. And I think this is the, so to speak, the best ad hoc way that now stops, because I'm not forced to translate all that stuff, to explain the difference between structural and epistemic impression. A structural impression is about what the Constitution actually says. We know this for certain, but so to speak, it ends, and there are some different versions for the legislator. With epistemic uncertainty, the epistemic discretion, all this uncertainty, empirical or even normative uncertainties come into play and typically lower the entities in the balancing which they affect. This is, so to speak, I think the easiest short explanation. Thank you.
Thank you, Professor. Estimado Arnulfo, si nos pudieras ayudar, por favor. Sí,
Muchísimas gracias.
ok, justo eso iba, sí quedó claro, ¿verdad, César? Muy bien, muy enriquecedor que además de que Arnulfo sea nuestro traductor de lujo, pues es un experto en la obra del profesor Borowski, entonces el contexto y la explicación se expanden. No sé si haya alguna otra pregunta o ya con esto podemos finalizar. Ya para respetar el tiempo del profesor, me parece que ya no hay. We said, Professor, that it's very enriching that Arnulfo, as a translator, is also an expert in your work. So the context and explanation are expanded, and that.
It actually might be easier to ask him rather than asking me and letting this. I think he could answer the questions also without me very well, I should say. But yeah.
Well, dear Professor, thank you very much for being with us on behalf of our university and the network we have with the University of Antioquia, Colombia. We greatly appreciate you making a space for us in your very busy schedule. It has been a pleasure to have you among us. Since your work is one of the most representative, not only in European, also global constitutionalism. We wish you success in all your activities and hope that we have you again soon among us, dear Professor.
Well, thank you very much indeed, and it will be a pleasure to come back if you would like to have me again. So yeah, please ask and call. And thank you for your kind words and for actually these interesting and good questions and allowing me to present some thoughts to such a distinguished audience. Thank you. Thank you.
Thank you very much, Professor.
Bye-bye.
Y a nuestro auditorio, pues muchísimas gracias por haber estado con nosotros esta conferencia magistral con la cual arrancamos un ciclo permanente de grandes presentaciones de las y los juristas más reconocidos el día de hoy a nivel internacional. No hubiese sido posible sin el concurso, sin el esfuerzo institucional de varias asociaciones involucradas, empezando desde luego por nuestra Universidad Juárez del Estado de Durango, a través del Instituto de Investigaciones Jurídicas, del Grupo de Investigación Democracia Constitucional, Transformaciones Sociales, Libertades y Derechos, de la Red Internacional de Investigación sobre Democracia, Derecho y Política desde México y Colombia, que mantiene la UJED con la Universidad de Antioquia, Colombia. Varias integrantes de esa red aquí han estado presentes. Quiero agradecerles de manera muy puntual a todas y todos. Y un agradecimiento muy puntual a Arnulfo Mateos, que ha hecho posible con sus buenos oficios y también con su labor de traducción y de gran conocimiento muy profundo de la obra del profesor Borowski, que este acto haya tenido verificativo. Esperamos que sea el primero de muchos y también anunciamos que Arnulfo lo vamos a tener próximamente también en una conferencia sobre la prisión preventiva. Muchísimas gracias a todas y todos por su atención. Muy buenos días todavía aquí en México, ya tardes en Colombia y noches por allá en Europa. Arnulfo, dear Professor Borowski. Gracias a todas y todos. Hasta luego y muchas gracias.